to address the court briefly, to assist the court where the court is making. And my Lord, I would, at the very outset, wish to draw the attention of this honorable court to Article 165, Sabbatical 4, which provides, my Lord, that where the High Court, this honorable court, certifies that the matter raises a substantial question of law, the High Court will refer the matter to the Chief Justice to constitute a bench, an uneven bench, to hear the matter. My Lord, it is our submission, without going into the merits of the issues raised, that the petition here and the application for conservatory orders raise very weighty, undisputably very weighty. One, my Lord, we raise the issue regarding the constitutional validity of Standing Order number 64, 2 and 6, the Standing Orders of the National. 64 or 64? It is Standing Order number 64 in brackets, sub-rule 2. And sub-rule 6. So it is Standing Order number 64, sub-rule 2 and sub-rule 6, providing, my Lord, a period of only 12 days to deal with and dispose of impeachment of the Deputy President of the Republic of Kenya. And I should add, it's also the one that applies to impeachment of the President. My Lord, the Supreme Court, in the case of American Tobacco and the Cabinet Secretary of Health, gave guidelines regarding public participation. So the issue we will be arguing is that this Standing Order, providing for that drastic time limit within which public participation in terms of the guidelines by the Supreme Court, I am deliberately not going into those guidelines at this stage. I'm just pointing out, my Lord. We will be saying that the 12 days limitation is in head-on collision with Article 50 of our Constitution, that grants every person the right to a fair trial by any court or tribunal or any other body. My Lord, it is important when you look at Article 50, it is an independent court, independent and impartial tribunal, or other body. So when the National Assembly is carrying out these quasi-judicial proceedings of impeachment, it has to comply with Article 50. And my Lord, that right to a fair trial is one which cannot be limited. That is in Article 25, Subarticle C. So these are weighty issues. Particularly, my Lord, in a presidential system of government as opposed to a parliamentary system of government. The 2010 Constitution established a presidential system of government. The point I'm making here, my Lord, is that it is not a question of a majority in the National Assembly, for whatever reason, saying we have no confidence in so and so. The fact that you may have the numbers does not entitle you to impeachment. There has to be proof of gross violation of the Constitution or other written law. And my Lord, this is of particular importance given the provisions of Article 1. So, my Lord, what I'm saying, yes. I'm just demonstrating. Yes, I'm merely demonstrating why your Lordship must not have any hesitation in certifying that this matter should go to the Chief Justice. But I had reserved the most important critical article. Validity? Yes. The second one is public participation. Yes. I've touched on that. And we are arguing it was wholly inadequate, given the guidelines given by the Supreme Court. That's the second issue. The third issue is the impeachment in a presidential system of government. It is not a question of numbers in the National Assembly. And I was winding up, my Lord, to leave it to my friend Elisha Ongoya, that Article 1 is critically important. When your Lordship is considering whether the issues raised in the petition and in the notice of motion are sufficiently weighted to justify sending this matter to the Chief Justice, bear in mind that in a presidential system, we are talking about the sovereignty of the people who elected the president and the deputy president. But Lord, I am just drawing this noble court's attention to the fact that our elected members of parliament exercised delegated authority, delegated by the people of Kenya, who continue to retain sovereignty. So does the executive. and so do the courts, my lord. So that when we are interpreting, when the court is called upon to interpret and apply this constitution, it must start with the sovereignty of the people. And where the impeachment, therefore, is to remove from office those who were elected by the people. It's an extremely weighty matter, so that Article 50, the article regulating the removal, the standing orders, all have to be related. The Constitution must be interpreted as a whole. And the starting point is the sovereignty of the people in Article 1. So these are extremely weighty matters, and the directions that we plead your Lordship makes, given these weighty matters, is that this petition and our motion seeking conservatory orders, which the argument on the conservatory orders application will go to great lengths in arguing these issues. We would like to do that before a bench of more than one judge, an even number. In simple language, a bench of 3 or 5 or 7 judges, according to what the Chief Justice might direct. I hand over to my friend Elisha Ngoya. Up to you. We'll be happy to argue that with you if our request is acceded to. The Senate has filed grounds of opposition. There's no other material from the respondent before this honorable court. So a lot of the other things that you are being told is evident from the bar. I do urge your Lordship to concede to the application which was first raised in, spent a lot of time submitting on the merits of both our petition and our notice of motion. My Lord, as far as the petitioner applicant is concerned, this afternoon we confined our submission to assisting this honorable court when giving directions to accede to our requests for this matter to be taken to the Chief Justice. So that even when mentioning the issues that arise, we refrained from arguing the merits of the issues, because we would like to do that before a 3-judge or 5-judge or 7, whatever the Chief Justice might imply. That's the only issue we addressed. My Lord, you've been told the issues we raised have been overtaken by events. My Lord, nothing could be further from the truth. For example, the constitutional invalidity of Standing Order number 64. Sub Order 2 and 6 has not been overtaken by it. It's a very live issue. And it is this Standing Order that regulated civic education. My Lord, anything done contrary to the Constitution is a nullity if the court agrees that this standing order is a nullity. And my Lord, the petitioner is not to blame at all. There is pending in the National Assembly a bill that originated from the Senate that sought to prescribe how impeachment should be conducted. It is still lying dormant before the National Assembly. So the fallback position is for the court to do the best it can on such issues. And for example, a fundamental issue relating to civic education. How do you conduct civic education and take to the voters only one side of the matter, the allegations, before you give the subject of impeachment the opportunity to state? Then you take both the allegations and the answer to the citizens so that they can make an informed decision. You know, so there are these weighty issues, which is why we are pleading that your Lordship give direction. Because this is the first time, my Lord, that impeachment of a deputy president of the Republic of Kenya is taking place. Let's not confuse the procedures relating to governor with the procedure for impeachment of the president and the deputy president. Lord, these are weighty issues. Being told that these have been overtaken by events. I mean, what comes to my mind? It's like our opponents are asking us, he has not yet been hung. You know, when we used to hang people, now they stay in committee. Wait for him to be hanged. Then you can do we don't want a posthumous pardon. So, my Lord, kindly consider seriously sending this matter to the Chief Justice so that we can argue each one of these cases wholly, not just for the sake of the events today. This is what is going to guide future jurisdiction. And my Lord, please bear in mind